Cash is the fuel of your business. And often when a business is successful, it expands too quickly. So you've got to buy stock, you've got to pay people, you've got to basically get your business up and running so that it can grow. What is the biggest problem of South African SME? Cash. They run out of cash because you can't get finance. If you're starting off your own business, you run to dad and say, I need 10,000 Rand to start a business. If you are successful, I can guarantee that you'll be running to dad within a month and saying, well, dad, I need another 20,000. I've made a profit, but my business has expanded and I need to buy more stock. And I haven't been paid by my debtors yet. Now, this has been one of the big controversies historically that has existed with with all the chain stores. Let's say, for example, you are an entrepreneur and you go off to Pick n Pay, and you say to Pick n Pay, I've got a great idea here, and they buy into it. Then they say, I'll pay you 30 days, or I'll pay you 60 days. That means you have to finance your business. Now, your business starts growing and you haven't been paid for the last lot that you've sold. So then you're in trouble. And this is a major factor in business failure in South Africa today. So what you've got to actually do with it is you've got to say, in starting a business, we can run into financial problems, particularly with successful entrepreneurs. If I overtrade and my debtors don't pay on time, I'm going to run out of cash. So when you get the Companies Act being rewritten in 2009, what we get is that they said we need to find a way to protect particularly small businesses, where you give them a breather. I think you might have seen that with individuals as well in South Africa. If you owe less than 50,000 Rand, you can put yourself into a position for a while where you get a breather from your creditors. What Business Rescue does is it does just that. It says, the new Companies Act wants to bring in an entire new chapter to business rescue and compromises with creditors. The chapter provides a measure of relief for a financially distressed company by putting a moratorium on their obligations and appointing a licensed business rescue practitioner for a company to help it sort itself out. That is all claimed in Chapter 7 of the Companies Act, but there's a procedure that you have to follow. If you follow the procedure, then you can claim interim relief from your creditors while you get your cash flow in order and save your business. So it's a very valuable asset if used properly by business. The problem is it's not always used properly. So the first thing that you've got to show if you get into trouble is that you are financially distressed. Because obviously if you're going to have a provision in the Act which says you don't have to pay your creditors for a while, there are going to be opportunists around who are going to jump at it, right? So what it says is, if it appears reasonably unlikely that a company will be able to pay all its debts as they become due and payable within the immediately ensuing 6 months, or it appears reasonably likely that the company will become insolvent within the next 6 months, then you are in the game of business rescue. A company, on the other hand, goes insolvent when its liabilities exceed its assets. It's not the same in business rescue. In business rescue, it doesn't have this measurement of liabilities exceeding assets. Its simple test is, can you pay your creditors? No, I can't, therefore I am financially distressed. Now, What you have to do before you call out for business rescue and a moratorium on your debts is that you have to prove that there is a prospect of recovery of your company. Now, watch out for this when you make a distinction in insolvency. When your company is insolvent, in other words, that its liabilities exceed its assets, and you do not do something about it, and you carry on in trading and you carry on knocking up more debt, then you can be accused of what's called reckless trading in terms of the Insolvency Act. And that is the one act of insolvency for which you can actually go to jail. You can't go to jail anymore because you can't pay your debts. That's not true. You can't do that. But, however, in this we've got to say, if you've got a prospect of that you've only got a liquidity problem, and the directors apply their minds, well, then they're saying there's got a different thing here. We're in distressed circumstances, okay, from a conspiracy of circumstances. It can be anything that has driven you to the brink, if you want, on your cash flow. Then, starting off, business rescue proceedings may be initiated by the company itself or by an affected person of the company. So, what happens there is it is normally the company itself. It says, I can't pay. Now, what are you going to do about it? You can either say, dump the company and liquidate, or you can say, there's nothing wrong with this business model, it needs to be tweaked a bit. I just need some time. So when the company says, I can't pay my debts, then we have a situation that the board has to have reasonable grounds to believe that the company is in financial distress. But, and this is critical, there is a reasonable prospect of regaining the company. That is in terms of Section 129.3. So you're saying, I could save this company. If the thing's a dead dodie, gone, finished, your obligation as a director is to apply for insolvency proceedings and close the company down before it does any more damage. However, we take this further now and say if there is a prospect of rescuing it, we go another way in terms of Section 129. Within 5 days of adopting and filing such a resolution, the company must notify every affected person of the resolution in the prescribed manner, including a sworn statement of the facts on which your resolution declaring business rescue is made. So you go around to all your creditors and you say, I can't pay you in terms of Section 129 of the Companies Act. Then we take those provisions and we go further. We then appoint a business rescue practitioner within 5 days. So what you've got to realize as the downside to business rescue is quite simply, if you don't go and make the application, the creditors can ask for the money. If you want to make the application for business rescue, then you go along, you make the affidavit, you tell everybody about what you are doing, but you can't carry on flogging the dead horse. You've now got to hand your business over to a business rescue practitioner. You go out and you appoint one. And then once the practitioner has been appointed, a notice of appointment must be filed within 2 days to all affected persons who must be notified within 5 days thereafter that a notice has been filed. Who is the business rescue practitioner? Now, if the company fails with this procedural position, then the resolution lapses and the company cannot make a similar application for business rescue proceedings for the next 3 months, by which stage you will be out of business. So what you do in a business, and this is where you really are between the devil and the deep blue sea, is that you go and find a business rescue practitioner. Before you tell anybody, and you say to the person, here are my facts, would you like to be my business rescue practitioner? Now bear in mind that this person has to be registered as a business rescue practitioner. They will look at the business. The important thing that then comes along is that the business rescue practitioner must do all the documentation to get you into business rescue. Because if you stuff up the documentation on getting into business rescue, do not pass go, you're kicked out of business rescue, and what's more, you can't just start again for another 3 months, by which stage all will be lost and your company will be sequestrated. So if you want to summarize the steps at this stage, I'm in trouble. I can't pay my debts. The last thing you can do is do nothing as a director. You have to take steps. So either you've got to find some more money. If that doesn't work, you've got two routes. You can declare your company insolvent, and it's wound up, or you can go the business rescue route, which says, I've got a prospect of recovering this business, but I've got to hand it over to another person, a business rescue practitioner. We've got to get the documentation right before we even start on this little adventure. So, if the board believes that the company is distressed but does not adopt a resolution to commence business rescue proceedings, it must notify all affected persons that the company is distressed together with the reasons for having such a resolution. Now, your creditors can say, I object. An affected person can apply to court to set aside the resolution at any time after it has been adopted, but and before a business rescue plan is adopted. Now we're going to come to a business rescue plan in a minute. But what you've got with this is obviously if there is a breather, then people are going to go for it. They're going to abuse it. And most companies that are financially stuffed are in a position where they've got to basically say, look, I'm stuffed, I must liquidate because there's no prospect of saving it. But they will run the business rescue route and say, of course there's a prospect of saving it, to get another 3 months opportunity on what they're doing. Do you see how the players can get into the game? A very good example of this was One-Time Airlines. Do you remember them? Now, there's always been discount airlines in South Africa. We've had Nationwide, we've had One-Time, we've had Intercity, etc. They work when times are good on the oil price. When they go bad, and it's generally because the oil price is too high and they can't keep going. Now, if you take One-Time, One-Time was started by Nando's, believe it or not. They said, let's run an airline. There are lots of old jets sitting in the yard of Safair in Johannesburg. We'll just hire their jets, paint them in our colors, and do discount airlines. And that worked for a while. Then the oil price ran to $110 a barrel, and the fuel price went with it. At $110 a barrel, a discount airline cannot operate. It's stuffed. A third of its overhead is just the fuel that went in the planes. So One-Time Airlines came along when they got into trouble and they said, we are applying for business rescue. And the creditors came along and said, no, you are not. You've got no prospect of ever recovering from this. Do you see how that works? And they threatened to take them to court, and One-Time actually abandoned its business rescue application and went insolvent. Thereafter, the oil price dropped, it halved. Okay? And what replaced One-Time? Fly Safair, right? And we're doing exactly what One-Time was doing 2 years later. It's quite extraordinary what the oil price can do to these things. But at the time that One-Time went bang, Nobody ever believed that the oil price would reduce. And so there was no prospect of ever rescuing one time. And so it had to be liquidated. And that's the first thing that you've got to do when it comes to business rescue. You've got to say, hang on, is there a prospect of finding more money? Otherwise, you must go the insolvency route. Right. So we have objections. Objections can be made on the grounds that first, the company is trying a fast one, there is no prospect of ever recovering it. Or secondly, that there is a reasonable prospect of recovering the company. If that be the case, carry on, okay? But you have to show that you've done all of that. Once you've done all of that, the company needs to show that there is a prospect of success of getting it back. So there are procedures to be followed, as with everything these days. I would suggest that if ever you get yourself into a business rescue problem, please don't try and do it yourself. That's the last thing you want to do. If you do it yourself, then you're going to go procedurally wrong. And if somebody challenges it, you're going to get thrown out. And if it's thrown out, you can't come back then for a period of 3 months. So the procedures are important. If somebody challenges it, they've got to go to court to set aside either the actual application, or they can come along and say, the business rescue practitioner who you've tried to appoint to fix your company is not an appropriate business rescue practitioner. Right. In addition, a person may apply to court to require the practitioner to provide security to secure the interests of the company and any affected persons. So what that is saying there is that saying the practitioner is, he reckons he can do it, but he might lose us even more money. So the practitioner must then give in security to show that he is of good faith and can do it. Then the company commission and each affected person must be notified of the application, and each affected person is allowed to participate in a hearing of an application to court in terms of Section 30. The court may then either set aside the resolution or allow the practitioner sufficient time to form an opinion as to what is going on and whether there is a reasonable prospect of ever getting this thing back on the road again. If the court does set aside the resolution, it may make further necessary and appropriate orders. So what might happen is a creditor would say, look, this was a fast one. I'm now bringing an application for the company to be liquidated. The court can include placing the company under liquidation or ordering costs against any director if the court finds that the director did not act in good faith in favor of making the resolution in the first place. So you've got to be careful here. You can be personally liable if you drive a company into business rescue proceedings and there is no prospect of ever recovering that company. So let's be very careful on that one. If the court sets aside the appointment of the practitioner, normally that either he's not independent or it can be that he's not qualified to do the job, then you would appoint an alternate practitioner who is recommended and acceptable by the majority of the parties involved in the application. If the company does not adopt a resolution to go for business rescue, an affected person may also apply to court and say, for goodness sake, these people are out of control. This company is rescuable. I want it put under business rescue so that I can get an independent person in there to look at what is happening and to put the company straight again. Now that could be useful, for example, if you have a family-owned business where you've got various shareholders in a family-owned business, and the directors are not doing their job properly, you may be of the opinion that if the company is run properly, then we can get that money going again. We don't want to liquidate the company. We don't want to destroy it. So you can then go to court and say, I want an application to put that company under business rescue, which kicks out the current management and replaces it with a business rescue practitioner, and we can take it further from there. And the court will make an appropriate order as to how this should be sorted out. But, next thing, if liquidation proceedings have already commenced at the time of an application for business rescue, then liquidation proceedings can be suspended until the court has adjudicated these proceedings. The court may set aside the company's resolution and may make appropriate orders, including liquidation orders, including costs orders. If the court believes that there is no reasonable ground for believing that a company is financially distressed, it may order costs against any director who voted in favor of actually going towards business rescue. So be careful. When a court has placed a company under supervision, it must notify every person of the order of the court within 5 days. The court may set aside a company's resolution and make alternative orders. I think we've covered that one. Business rescue proceedings then begin. Business rescue proceedings begin when the company files its resolution or an affected person gets a court order. You've then got business rescue proceedings. And what happens is that the court sets aside the resolution or converts proceedings into liquidation proceedings when the practitioner files a notice of termination. The practitioner can walk in there and say, there is no prospect of ever saving this company. I therefore basically terminate this application. It must go into liquidation. Or the business rescue practitioner can look at it and say, I'm coming up with a plan. That's your business rescue plan to rescue a company. I'm going to implement that plan and put the company back on its feet again so that it can come out of business rescue. If business rescue proceedings take longer than 3 months, the practitioner is required to make a progress report to every affected person, to the court, and to the company's commission. And what he says then is, I can't use this legislation as a delaying tactic for longer than 3 months unless I've disclosed it to everybody. I can ask for another 3 months if I can show that there is going to be a rescue. There's got to be reasonable grounds. Otherwise, if he can't show those reasonable grounds within 3 months, the answer is, you go the liquidation route. So all along, what you see with this legislation is that it is seeking to cater for the fact that there are sharpies out there who are always wanting to make a quick one on this. Now, what is the effect? You've got your company into business rescue. You've shown you're financially distressed. You've shown that the company can be registered. It can be fixed. You've appointed a business rescue practitioner correctly. All of those things done. Now, what's the next step? We have to say, right, everybody hands off that company for 3 months. You've now got a moratorium while they sort everything out. Creditors hold back. And what happens is that you can't call up any debt, you can't call up any guarantee, any surety, but there is a time limit. Creditors hold back for 3 months no matter who you are. Even SARS, once you have got yourself into business rescue. Then, in the course of the time of that 3 months, you can carry on with bona fide transactions at fair value, okay, if they are approved by the business rescue practitioner. Now, there's always a danger in this for the sharpies again, to come in there during that 3 months and sell off everything for nothing, normally to their mates. That's why they put in the thing there, that bona fide trade may carry on. In accordance with the approved business rescue plan, okay, we can carry on trade. And there will be preferential payments made. Now, preferential payments, when you look at business rescue, is the debts that you have knocked up to the date of your business rescue. Those are on a moratorium, okay? But preferential payments are for payments made after you've gone into business rescue. You say the old creditor's got to hang back, okay? Now, what happens then, of course, is the staff. What do we say to the staff? Now, they have a preferred claim against the company. But if they don't come along with the deal, then they go into liquidation. Are they going to get paid anything? Probably not. And this is where in some of these cases we have to say to the staff, look, I know I owe you money. Maybe one day I'll be able to pay it back. Let's come to a deal whereby from this day forward I can pay you for the work that you've done, and we will go back to what I owe you in the past. There are also preferential terms with regard to medical, pension, and provident schemes. They are unsecured creditor amounts if they were due and payable before the commencement of business rescue. Now be careful on this, because we're going to get another form of preferential creditor in here as well that sits in the same class as this, SARS. These are preferential creditors. This is the employee's money or your vendor's money that hasn't been paid over. You are now saying, I can't pay it. But you've taken that money from those people in a position of trust that you will pay it over. So you've got to be very careful when you admit that you can't pay it over, that you're not accused of theft. And that is where people can really go to jail. So, any other financing obtained during business rescue proceedings, where, for example, you go and get money from a new investor, they get preference on payout to those who had given finance before business rescue. And of course, somebody has to pay the practitioner and all his expenses arising out of the business rescue. And I'll tell you this about business rescue practitioners. They will never take on a case like this unless their fees are guaranteed or paid up front, because they're in a risky business, even though their practitioner's fees are payable in advance. If liquidation proceedings are converted into business rescue proceedings, the liquidator is a creditor for his remuneration due for work performed or expenses incurred before business rescue proceedings were there. So he is just a creditor then. He's got to sit back and get paid later. He can't come along and take the company down because the liquidation proceedings have not commenced. So there is an order of preference in the payment of people when you are in business rescue. Practitioners' remuneration and expenses and other claims arising out of business rescue proceedings are paid first. Then comes employees' remuneration, but the remuneration post business rescue. Okay, then other post-commencement financing that you may have obtained, then unpaid employee remuneration for employment payable prior to the commencement of business rescue, plus their medical and provident schemes, etc. During the business rescue, no changes may be made to the classification of your securities without the consent of a court or in accordance with the business rescue plan. Each director of the company continues to function as a director, subject to the authority of the practitioner. So the directors stand back and they say, Mr. Practitioner who walks through the door here, right, you're God in this company now. What can I do to assist you? But they can't direct the business rescue practitioner what to do. provided the director performs his functions as required by the practitioner and discloses all his personal financial interest in the company, in accordance with Section 75 and 76, he is then relieved of his duties unless he is asked to do something by the business rescue practitioner, then the directors. The directors are required to now cooperate with the business rescue practitioner and provide him with all the information that he needs to run the company. The practitioner may apply at any time to court for an order to remove a director from office. So if a director is giving them trouble in trying to resuscitate a company, the business rescue practitioner just runs off and bango, he gets an order. That director is then taken off the board of the company. Now, employees and contracts. Employees of the company immediately prior to the commencement of business rescue continue to be employed on the same terms unless they agree different terms. So business rescue doesn't mean that everybody's fired. All it means is that arrear remuneration doesn't have to be paid immediately. So we go along to the union, and this is a very important part of business rescue. One of the reasons why we have business rescue is to say to the employees, listen, we're trying to save your job. Give us a breather and we'll sort it out. You're still employed while the business rescue carries on. But let's renegotiate a new package. This might be where you talk to a union and say, part of the business rescue plan is a staff reduction. We're going to thin it down a little bit. But we're going to save some jobs. If we liquidate the company, there will be no jobs. And that is the important reason why we have Section 136. If retrenchments are contemplated as part of the business rescue plan, there are no separate rules in terms of the Labour Relations Act. You will do it in the usual course. Employees thus have some form of protection in what they are doing. The practitioner may suspend entirely, partially, or conditionally for the period of the proceedings any obligation of the company or any agreement to which the company was a party until such time as you come back out of business rescue. The practitioner may also apply to court to cancel any obligation of the company on terms that are just and reasonable. So if you have a contract that you've signed that is killing the company and that is obviously unfair, unreasonable, etc., the business rescue practitioner will take that to court and say, cancel that contract so that the company can carry on again. Now we come to the business rescue practitioner. He is an officer of the court and has the same duties and responsibilities as a director. He sits in the director's shoes for while he's there. Consequently, he must be not subject to any of the disqualifications in terms of the MOI or in terms of the Companies Act. He must not have a relationship with the company or with any other related person that would compromise his objectivity, integrity, and independence. The Act sets out who may be appointed as business rescue practitioners. And this has got to a large degree to do with the costs of them. So what they've done with it is that they have said a business rescue practitioner must be a member of good standing in the legal, accounting, and business management professions. They apply, and there are regulations where you may register yourself as a business rescue practitioner in terms of Regulation 126. They will take into account the qualifications and experience and required memberships of professions in assessing whether you can be a business rescue practitioner. You then apply for a license by filing a form with the company's office and paying a fee. The types of business rescue practitioners are those who work with large companies with a public interest score of more than 500. Then we have medium companies who have a public interest score of between 100 and 500. And then we have small companies who have a score of less than 100. So what we put it in those three categories, and then they say a senior practitioner is a person who's got 10 years experience in this. He may do large companies, medium companies, and small companies. An experienced practitioner, he can do companies with a public interest score of less than 500, the medium-sized companies. And then we get junior practitioners. They can do the smaller companies with a public interest score of less than 100. So they get appointed for small companies, juniors, experienced for medium, and seniors can do any one that they want. Then there is a regulation that sets the tariff for the business rescue practitioners. Some charge more, and a lot of them say, money in my bank before I'll even start. But we have to get them. Additional fees may be charged for their disbursements, for additional work that is required, for engaging in other people, etc., and all the costs of this. The practitioner has full management control of the company in substitution for its board or any pre-existing management position, and the practitioner may delegate any power or function or remove a person from office or appoint people to execute his business rescue plan. He then develops his business rescue plan and says, this is how I'm going to do it. The practitioner must investigate the company's affairs and have a look at the whole thing and saying, what's the problem here? Once he's got to the bottom of the problem, he must say how I'm going to fix it. Okay? And if there are any voidable transactions, how I'm going to cancel them. And if there is evidence of any reckless trading in the company or contraventions of the law, then, he must go and prosecute those people. He must come up with a business rescue plan. Then he goes to all affected parties, publishes the plan, and says, convene a meeting 10 days later. We then have to adopt or accept the plan, or we say we can reject the plan as well. If we reject the plan, well, then the business rescue has basically failed. In the course of the plan, we may come to a compromise with our creditors. So we say to the creditors, we'll pay you X cents in the rand. And they come along, we pay them that, and then we carry on because we've been given a breather by our creditors. Why would the creditors want to do that? Why would a creditor want to help? Because they're hoping for the future business that will come from the rescued company. The proposal on a compromise must have all relevant information as specified by the Act, details of the proposals and all assumptions and conditions on which it is based. So we then say we have to have a compromise with creditors. A copy of a court order of compromise must also be attached to the company's MOI and is final and binding on all creditors of the companies. That is if the compromise is accepted by a court. An arrangement of compromise does not affect the liability of any person who has a surety in the company. That has to be separately negotiated. So, what have we done here? We said there's a procedure. The procedure might help you rescue a company. So now what we're going to do is have a little break for tea, and then we will consider a practical example of it after tea.